Hi, this is Ken Barron with the National Association of Black and White Men Together. Today, the affirmative action threat from the Supreme Court. The future of affirmative action in a pair of cases at the Supreme Court challenges race-conscious admissions at Harvard and University of North Carolina. This may have consequences in other areas of our lives. Thurgood Marshall once argued, quote, "Unless our children begin to learn together, there is little hope that our people will ever learn to live together." But the court is now dominated by a six-member conservative supermajority, likely to imperil more than 40 years of precedents. In June, the justices overturned Roe v. Wade, the 1973 decision that had established a constitutional right to abortion. The court has repeatedly upheld similar programs, saying that educational diversity is justified to take account of race as one factor amongst many an admissions decision. When the court agreed in January to hear the two cases, it consolidated them and said it would hear a single hour of arguments to follow it. The court decoupled the cases, however, when Justice Brown Jackson accused herself from the Harvard case in the light of her services on one of the university's governing bodies. As a public university, UNC is bound by both the Constitution's Equal Protection Clause and the Civil Rights Act of 1964, which bars race discrimination by institutions that receive federal money. Harvard is a private institution and it's subject only to the statute. Both cases were brought by Students for Fair Admissions, or SFA, and this is a group founded by Edward Blum, a legal activist who has organized many lawsuits challenging race consciousness admission policies and voting rights laws, several of which have reached the Supreme Court. In the North Carolina case, the plaintiffs said that the university discriminated against white and Asian applicants by giving preference to Black, Hispanic, and Native American ones. The university responded that its admissions policies were lawful under long-standing Supreme Court precedents. The case against Harvard accused the university of discriminating against Asian American students by using a subjective standard to gauge traits like likability, courage, and kindness, and by effectively creating a ceiling for them in admissions. Harvard denied that it discriminated against Asian American applicants. When the Supreme Court, in its last major encounter of affirmative action in higher education, it rejected a challenge to race-conscious admissions program at the University of Texas at Austin in 2016. Justice Alito wrote the main dissent. In the 2016 in Fisher versus University of Texas, SCOTUS sent a basic message that admissions officials may continue to consider race as one factor amongst many in ensuring a diverse student body. In a written dissent, Justices Alito, Roberts, and Thomas said the university had failed to demonstrate that its race-conscious admission program advanced concrete goals. Justice Anthony Kennedy wrote that the majority opinion helped affluent Black students and hurt Asian American ones. When can college stop considering race? Quote, "How do you know when you're done?" Amy Coney Barrett asked Park, a lawyer for UNC. The UNC lawyer responded that the UNC is already using race in a minimal way, and we will get there, he said. UNC excluded Black students and faculty members for most of its 2033-year history. Over the years, its leaders included the state's largest slaveholders, officials of the Ku Klux Klan, and defenders of Jim Crow, according to one historian. Barred from using the swimming pool and house an in an all-black floor of zonatory, those students face isolation. The impact and legacy of this history on students of color cannot be overestimated. Despite recent efforts to foster a diverse student body, Judge Biggs of the Federal District Court for the Middle District of the North Carolina wrote last year in a ruling in favor of the university that students of color were still confronted with racial epithets, as well as feeling isolated, ostracized, stereotyped, and viewed as tokens in a number of university spaces. SCOTUS has made and will make these rulings that imperil the lives and ambitions of people at the margins. We must support politicians that protect our rights and freedoms. This is Ken Barron with the National Association of Black and White Men Together. Please go to our platforms. nabwt.org is our website. You can follow us, subscribe, and comment. We appreciate your feedback. Thank you so very much.